What is the idea that animals should be able to sue humans? The idea that animals should be able to sue humans is the proposal that non-human animals would have legal standing through human representatives to bring civil actions in court to prevent harm, seek remedies for abuse, or enforce statutory protections. Put simply, it imagines a courtroom where an elephant, a chimpanzee, a dog, or a whale does not appear in person, of course, but is recognized as the beneficiary of the case, with a guardian or next friend speaking in its name. That is the clean definition. The intrigue begins when we ask whether our legal system, which already lets corporations, trusts, and sometimes even rivers or ecosystems be treated as legal persons for limited purposes, could similarly acknowledge an animal's interest in not being harmed. A quick origin story helps. For centuries, the law treated animals largely as property, while at the same time punishing needless cruelty. The modern animal law movement pressed a sharper distinction between welfare and rights. Welfare says we may use animals but must minimize suffering. Rights asks whether some uses should be off limits because animals have interests that the law must respect. Courts and legislatures have experimented at the edges: stronger cruelty statutes, habitat protections, and species-specific safeguards. The question of standing is the next frontier. If a statute says an animal must not be beaten, starved, caged in certain ways, or trafficked, who gets to enforce that promise when government enforcers decline? The answer today is usually a human plaintiff claiming personal injury or an agency acting in the public interest. The proposal on the table is bolder. Let the animal be the rights holder and, through a human representative, the plaintiff. How would that work in practice? The familiar tools already exist. Children and incapacitated adults sue through guardians ad litem. Trust beneficiaries have suits brought for them by trustees. Public interest cases proceed when an organization shows that at least one member is affected. Translating those models, a court could appoint a qualified guardian, bound by fiduciary duties, to represent a specific animal's interests. The guardian would file for injunctions to stop ongoing harm, seek restitution for veterinary care or sanctuary placement, and request court monitoring. Remedies would be tailored to the animal's best interests rather than to human convenience. Critics push back on two fronts. First, they argue that standing requires a concrete, individualized injury, and that allowing animals into court through representatives invites a flood of lawsuits untethered to traditional doctrines. Second, they warn of a slippery slope from limited protective suits to a wholesale reclassification of animals as persons, with cascading implications for farming, research, and cultural practices. Supporters reply that courts already manage floodgates with pleading rules, sanctions for frivolous filings, and case management tools, and that recognizing a narrow, carefully cabined form of standing need not rewrite every corner of property and resource law. The doctrinal hinge is not metaphysics but mission. What is a court for? If courts vindicate rights and resolve disputes with remedies grounded in evidence, then granting standing to a guardian for an animal harmed by unlawful conduct is a logical extension of existing practice. The real questions are prudential. Who may serve as guardian? How conflicts of interest are screened? Whether remedies help the animal rather than enrich advocates? And how to coordinate with public enforcement so efforts complement rather than collide. Examples make the stakes vivid. Imagine a roadside menagerie where a big cat is confined in filthy conditions that violate existing animal care regulations. Today, action depends on the pace and priorities of public inspectors. With animals standing, a court-appointed guardian could sue for an injunction, demand independent veterinary evaluations, and negotiate relocation to a licensed sanctuary, or consider a laboratory whose protocols allegedly depart from legally required standards. A guardian could seek a narrowly tailored order, compelling compliance without disrupting lawful research that meets ethical and regulatory thresholds. In wildlife contexts, a guardian might challenge a clearly unlawful capture, asking the court for release or transfer as the least intrusive, most welfare-consistent remedy. History also teaches caution. The law's legitimacy rests on transparency and restraint. Any animal standing regime must be built on rigorous guardianship standards, scientific expertise, and judicial humility. Courts would need clear evidence of harm, credible welfare assessments, and remedies that respect separation of powers. Legislatures, for their part, could define pilot programs, select species or contexts where individualized interests are most intelligible, and require data reporting so policy can evolve by evidence rather than by slogans. There is a philosophical curiosity at the heart of this debate. We already treat intangible entities, such as corporations, as legal persons for the pragmatic reason that commerce needs stable litigants. We have also begun to recognize the integrity of ecosystems in some corners of the world. Against that backdrop, recognizing a living, sentient being's interest in avoiding unlawful harm does not look radical so much as consistent. The radical move, perhaps, is the one we have long taken for granted, that a breathing creature with demonstrable cognition and social bonds has fewer legal tools than a paper charter. So, should animals sue humans? The lawyer's answer is disciplined and incremental. Yes, in tightly defined circumstances, through vetted guardians, with remedies aimed squarely at stopping unlawful harm and securing welfare, and with judicial safeguards that prevent overreach. No, if the aim is to smuggle sweeping policy changes through the back door of private litigation. The coming revolution, if it comes, will not be a thunderclap. It will be a series of careful steps that bring the law's remedial power into alignment with the moral intuition that sentient life deserves more than lip service when promises on the books are broken. Above, I leave you more videos so you can keep learning law. Remember to leave us a like and subscribe.